And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
9 justices, 0 disagreement. The Supreme Court has just issued a unanimous 9-0 decision in a case called Barnes versus Felix, a ruling that effectively ripped away a critical defense mechanism used by police officers in use-of-force lawsuits across 4 major federal circuits. This is not a partial victory. This is a complete reshaping of how the Fourth Amendment applies during a dangerous police encounter. It affects every traffic stop in America and holds immense importance for legal gun owners. Here is the central decision, delivered without exaggeration. The Supreme Court held that courts analyzing a police use-of-force claim must examine the totality of the circumstances, including the officer's actions leading up to the moment force was used, and cannot limit their review only to the final split second. That one sentence summary holds more power than you might realize. For years, federal courts in places like Texas, Louisiana, and the entire Fifth Circuit, among others, operated under a standard known as the moment of threat rule. This rule instructed judges to put on what the Supreme Court later called chronological blinders. They could only consider the precise instant the officer felt threatened. Everything that happened before that, whether the officer escalated the situation, whether the officer created the danger, whether the officer acted unreasonably for minutes leading up to the climax, was deemed legally irrelevant. Think about the absurdity of that standard. It allowed an officer to provoke a dangerous reaction, jump into a perilous situation, and then, when the situation inevitably exploded, claim self-defense based only on the final 2 seconds they perceived a threat. The court was forced to ignore the cause and only look at the effect. To understand why this ruling is such a necessary course correction, we have to look at the facts of the case itself. On April 28, 2016, a man named Ashen Barnes was pulled over outside Houston, Texas, by Constable Roberto Felix for outstanding toll violations, a routine stop. Barnes was looking for paperwork, told the officer he didn't have his license on him, and mentioned the car was a rental. Felix told Barnes to stop digging around. Then Felix said he smelled marijuana. Barnes offered that maybe his ID was in the trunk. Felix instructed Barnes to open the trunk from inside the vehicle. Barnes did, and he also turned the ignition back on. This is the critical turning point. Felix opened the driver's door and pulled his gun. Barnes started driving away, trying to flee. In a highly unreasonable act, Felix leaped onto the door of the moving car. He was literally hanging on the outside, head above the roof, unable to see inside the vehicle clearly. While hanging onto the side of the car, he yelled twice, "Don't move!" and then fired 2 shots into the vehicle. Barnes was hit and died, though he managed to stop the car 5 seconds later. The time from Felix jumping on the car to the first shot, 2 seconds. Barnes's mother sued Constable Felix, alleging excessive force and a violation of the Fourth Amendment. Both the District Court and the Fifth Circuit Court of Appeals ruled in favor of the officer. Why? Because of the moment of threat rule. The lower court said they could only look at those final 2 seconds when Felix was dangling from the moving car. At that moment, they concluded, any reasonable officer would fear for his life, so the shooting was justified. Felix's prior actions, including the irrational decision to leap onto a moving vehicle and thus create the deadly risk, were legally ignored. It is like starting a physical fight, getting punched in the nose, and then shooting the person in self-defense, while forbidding the jury from ever hearing that you threw the first punch. That is the injustice the moment of threat rule allowed. If you find this legal breakdown useful, you should know that the legal landscape for constitutional rights and self-defense changes constantly. You need Law Advisor keeping you informed. Take 10 seconds right now and hit that like button and subscribe, because the information in these videos could dramatically change the outcome of a police encounter for you or someone you love. Barnes's mother took the case all the way to the Supreme Court, and Justice Kagan, writing for the unanimous court, made the ruling absolutely clear. The Fourth Amendment demands a review of the totality of the circumstances. The court explicitly stated, quote, "A court deciding a use-of-force case cannot review the totality of the circumstances if it is put on chronological blinders." The justices weren't creating new law here. They were confirming existing, established Fourth Amendment principles. They referenced the Plumoff versus Rickard case, where a driver led police on a dangerous 5-minute, 100-mile-per-hour chase. Even though the chase was over when officers finally shot the driver, the court said you have to look at the entire sequence, the 5 minutes of reckless driving, the danger to the public, to judge the final reasonableness of the use of force. If the chase sequence matters, then the officer's actions leading up to the shooting in Barnes must also matter. Here is why this ruling is a massive win for licensed gun owners specifically. Every time you're pulled over while legally carrying, you're navigating a Fourth Amendment encounter. If that encounter escalates into force, this ruling is the shield you rely on. Under the defunct moment of threat rule, an officer could engage in grossly unprofessional conduct, shouting erratic commands, failing to de-escalate or making threats, and still be protected if he manufactured a final split second of perceived threat. Not anymore. Now, courts must look at whether the officer's actions created the danger. Did the officer issue contradictory commands? Did the officer bypass standard safety procedures, like asking you to step out of the car or securing the weapon first? Was the officer's decision to draw his weapon premature or reckless? All of this is now relevant, legally admissible evidence. Consider a hypothetical scenario that happens frequently. You are pulled over, and you properly notify the officer that you have a concealed carry permit and a firearm, perhaps located near your console. The officer, nervous, tells you to reach into your center console for your registration. As you comply, the officer suddenly yells, "Gun!" and fires. Under the old rule, courts only look at the movement of your hand towards the firearm. Was the officer in fear? Yes. Shooting justified. Under the Barnes versus Felix standard, the court must ask, did the officer create the threat by ordering a known armed individual to reach toward the weapon compartment without first giving clear, non-contradictory instructions or securing the situation? Did the officer's own panic cause the lethal outcome? The context of the officer's decisions leading up to that moment is now crucial to determining if the force was reasonable. This levels the playing field. It is important to note Justice Kavanaugh's concurring opinion, joined by Justices Thomas, Alito, and Barrett. He devoted 6 pages to correctly outlining how dangerous traffic stops are for police officers. Even after acknowledging the profound risk officers face, Kavanaugh still joined the majority. This is not about being anti-police. This is about maintaining constitutional standards. The Fourth Amendment requires that a government seizure, which includes using deadly force, must be objectively reasonable. You cannot determine reasonableness by ignoring the sequence of events that produced the crisis. The Supreme Court sent the Barnes case back down, instructing the lower courts to re-evaluate Constable Felix's actions using the full timeline. We do not know what the final ruling on Felix will be, only that the lower court used the wrong legal test. But the greater impact is on police departments nationwide. They now face increased liability if their training encourages officers to unnecessarily escalate situations, because prosecutors and defense attorneys can now scrutinize the full encounter in court. There is one critical element the Supreme Court pointedly did not decide, and it must be addressed eventually. They left open the question of whether an officer loses the right to use force if he intentionally or recklessly created the dangerous situation in the first place. Justice Kagan noted this question was not properly before them yet. So while we know courts must look at the officer's prior actions, we don't yet have a definitive ruling on whether the act of creating the danger completely nullifies the officer's eventual claim of self-defense. That massive constitutional question remains on the radar. For now, the essential takeaway is this. Courts can no longer hide behind a convenient 2-second window. The Constitution still applies, even when things get chaotic. Your rights do not vanish just because a court agrees to ignore half the evidence. This information could literally change everything about how police encounters are judged going forward. If you're serious about protecting your rights and staying ahead of the curve, you must subscribe to Law Advisor right now. My next video covers the exact legally tested phrases you must use when informing an officer you're carrying a firearm. The wrong words can escalate a situation. The right words can save your life. Do not miss it. The Barnes versus Felix decision is a unanimous declaration that the Fourth Amendment is a functional check on government power. The seizure must be reasonable based on the totality of the circumstances. This matters for gun owners because we are the population most often pulled over who then have to navigate the complex and stressful process of informing law enforcement we are armed. We need the full truth to matter if a tragedy occurs. The Supreme Court got this one right, and in doing so, they provided a vital new tool for defending constitutional rights and use of force litigation. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget. Knowledge is the ultimate defense. I will see you in the next one.